The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
Amid a flurry of SEC enforcement actions against crypto firms, SEC Chair Gary Gensler is making clear his view that most digital assets are securities that fall under his agency's purview. The Chamber of Digital Commerce, a crypto trade group, is fighting that notion at least one front, urging a federal court to dismiss a case against an ex-Coinbase staffer, arguing the case unfairly labels several cryptocurrencies as securities. Joining us now with more is Chamber of Digital Commerce founder and CEO Perianne Boring. Perianne, this SEC is suing a lot of companies. Ripple, Do Kwon and his Terraform Labs for issuing UST, Luna, Mirror, alleging they're unregistered securities. The Chamber of Digital Commerce filed an amicus brief supporting an ex-Coinbase employee, Ishan Wahi, who is accused of insider trading because in that case, the SEC has labeled several cryptocurrencies as securities. So why hone in on this particular case?
What's really novel about this case is that the SEC is has piggybacked on to a case brought by the Department of Justice, and they're latching on to a third party who had nothing to do with the issuance of these tokens, is not involved in the listing of these tokens, but using this case to define them as securities. So we take serious concern with this approach. We see this as backdoor rulemaking and just another step in the SEC's regulation by enforcement. It's super important to note that the SEC has never promulgated regulations under the Administrative Procedures Act to clearly define what sorts of digital asset transactions it considers to be securities transactions. And at the same time, the Congress is working on legislation that would restrict the SEC's jurisdiction in this space. So we see this action as seriously concerning and would have significant ramifications for the entire digital asset industry. And it was imperative that the industry had a voice in this case.
Do you think that the defendant should be tried at all for insider trading under any circumstance here?
Yes, absolutely. So one of the things that's really unique about this case is the DOJ brought the case. They're alleging insider trading. I want to be super clear that anyone who breaks the laws, breaks just basic code of ethics, we should absolutely enforce against those individuals. So in no way, shape, or form are we trying to downplay the seriousness of insider trading. What we have asked the court to dismiss is the SEC's case, which would have absolutely nothing to do with the punishments that will come of the individuals who have broken not only the rules of their employer, but also the law. So judicial restraint, it would not let these alleged wrongdoers get off the hook. They've already been indicted by the DOJ. They've pled guilty. They're certainly subject to an action for civil fraud as well. But a ruling that embraces the SEC's position and endorsing its tactics could have negative implications for the digital asset ecosystem. So great question and a really important distinction on why this particular case is very unique.
Does this case allow the SEC to lay out through enforcement how they see cryptocurrencies in terms as unregistered securities? I mean, they believe that securities follow the Wahi test. And so these are unregistered securities because they are an investment contract. They follow the Wahi test.
So the Wahi test sets a 4-pronged test for determining whether a given asset was sold as an investment contract and thus constitutes a securities offering, but it does not shed any light on whether the underlying itself is a security. Additionally, the Howey test was never meant to apply to the sorts of secondary market transactions that are at issue here, where there was no contract at all. Again, the SEC has never promulgated any regulations under the Administrative Procedures Act to clearly define what type of digital asset transactions it considers to be securities transactions. Congress is working on writing new rules that would limit the SEC's jurisdiction in this space. And the only type of guidance that we have from the SEC regarding digital assets is in the form of non-binding speeches and statements that have been conflicting from administration to administration.
Hey, Perianne, great to have you back on the show. Kind of want to zoom out for a moment here because this is just another example of sort of SEC madness and everybody's just getting so alarmed about it. And I just want to ask you your thought about one of these very popular narratives in crypto right now, which is that, because of the SEC's regulation by enforcement approach and because of the sort of general confusion in Washington, we're going to start seeing an exodus of crypto companies from the United States to other more friendly jurisdictions. I'm curious if you're hearing that in Washington and if you agree with that fear, which I'm seeing, more and more of in the crypto industry.
I think that's already happened. That's been an issue for many years. At the Chamber of Digital Commerce, we started raising these issues of not having any promulgated regulations from the SEC on what it constitutes digital asset securities. We started raising these issues back in 2016, and we saw that exodus and that brain drain. That time in crypto history was when we saw kind of the first wave of initial coin offerings, and a lot of those tokens left the United States. And if you just look at basic market data, you can see that the majority of digital asset activity does not happen in the United States. It's happening overseas. We have pushed innovation outside of the United States jurisdiction because of our lack of leadership in Washington.
Well, SEC Chair Gary Gensler has suggested that he's frustrated over the crypto industry's unwillingness to come through his doors. He recently told CoinDesk that these platforms aren't even coming in and asking for meetings, and saying that he really deeply respects the few that have come in. What's your reaction to that?
Chairman Gensler knows that it's not just as easy to go on the SEC's website and fill out a form. When he tells companies to come in and register, there is no framework for companies, for digital asset issuers, allocators, exchanges to register under. Additionally, there are a lot of companies that did go into the SEC, talked to the SEC, and came out with an enforcement action. So I don't know what other results the chairman would be looking for or would be expecting from the industry. Again, just going to point to the SEC has never promulgated regulations under the Administrative Procedures Act. They are regulating through enforcement and by press release, and that is not how you develop a healthy, compliant, and robust regulated market for any industry.
All right, Perianne. Thank you, Fan. Thank you for your time. That was Chamber of Digital Commerce CEO Perianne Boring.